This conference will now be recorded.
All right, so glad y'all could make it. You may or may not, you've probably seen a lot of the talk on our own Facebook group, probably other public Facebook groups in other places. And you know, kind of the impetus for this class was I would see agents saying things like, the real estate commission should get rid of due diligence fees because it's not fair to buyers. Or that, you know, the real estate commission should limit due diligence fees, or you know, I see agents you know, looking for changes in coming soon rules. And so, you know, number one, the real estate commission can't do anything about due diligence fees because they don't legally have the right to regulate contracts between private parties. And so we're going to start out here sort of with an overview of the different organizations that do have a finger in our business, talk about, you know, exactly what they can do, what they can't do, and particularly how what they do can impact us. So, and honestly, you know, this is something I've seen it more recently with agents discussing things like due diligence fees and coming soon, but it's actually a common recurring theme I hear among agents is they say, you know, this transaction fell apart. I think that, you know, the other party did something wrong. I'm going to complain to the real estate commission. And, you know, it may turn out that what they're really talking about is a code of ethics violation, which the real estate commission doesn't enforce. Or, you know, they may say that they, you know, the other party didn't hold up their end of the contract, they're going to complain to the commission. Well, the real estate commission does not enforce contracts either. So it's important to know, even in normal balanced markets, exactly who makes the rules. And, you know, if you want to get a particular rule enforced, you need to know who to go to help you with that. So obviously we'll start with the big one here, the real estate commission. You know, of course we know they are a government agency. They are a part of the North Carolina state government, but they have a very limited jurisdiction. They only oversee licensed brokers and firms in North Carolina. And that's anyone who's licensed here. You could live in South Carolina, but if you're licensed here, they have jurisdiction over your license. And they also have really well-defined rules that they're responsible for enforcing. So, you know, the first set, these are actually general statutes. These are state laws. Chapter 93A, real estate license law. They are responsible for enforcing these laws. A lot of this, frankly, is just about what qualifies you to be a broker. What do you need to keep doing to remain a broker? It does cover things like disciplinary actions, but these are state laws. The real estate commission cannot change these. The real estate commission cannot change state laws. These would have to be amended by the state legislature. So if you're looking through and you don't like something you see in here, you're going to want to write to your state congressman, your state senator, and tell them, hey, you know, this rule is terrible, it needs to be amended. And that would take a bill in the legislature, it'd have to go to the governor and be signed into law. Then you also have Chapter 58. I don't think it's copying the whole link there, is it? Okay, that did work. You got Chapter 58 of the state administrative code. Now, these are things that the real estate commission, I believe, can effect change over. You know, this would be where you would find, for example, those of you who don't yet know, the real estate just voted on the rule changes that will be effective July 1st. Those rule changes will be changes to this administrative code. So that's where you're going to find a lot more detailed information about the rules that the Real Estate Commission themselves have set. This is where you're going to find rules about handling trust funds. That basically the majority of Real Estate Commission rules are here in the administrative code, not in the general statutes. And then they are also responsible. They help enforce the North Carolina Fair Housing Act. So the Fair Housing Act, this is a general statute, this is a state law, but the Real Estate Commission is responsible for administering most parts of this as it relates to real estate brokers. Of course, there are fair housing issues that can impact non-licensed people, and those would not be within the purview of Real Estate Commission. But as a licensed broker, they would have the ability to regulate fair housing issues as they relate to your activity as a licensed broker. And of course, rules don't mean anything if there's not some sort of associated punishment. And so this general statute, again, general statute regulates what punishment can be administered by the Real Estate Commission. And the short answer is they can either reprimand you, they can censure you, they can suspend or revoke your license. It's important to note what they can't do. The Real Estate Commission cannot fine you. They cannot, even if the disciplinary action they're taking is based on a state law, they can't arrest you, they can't send you to jail, they can't make you pay anyone anything else. So for example, if they conclude that you caused financial harm to a consumer, now they may apply some pressure. They could say, hey, if you refuse to make that client whole, we'll revoke your license. If you pay that consumer X dollars to make this right, we'll only suspend your license. Or particularly for smaller amounts, they may say, hey, if you will, pay this amount to the consumer, we'll reprimand you instead of suspending your license. By the way, it's not an official disciplinary action, but it is possible they can just send you a nasty warning letter too. Typically, what will happen in that case is the regulatory affairs officer will write you a letter and they'll say, we're closing this case with no further action, but in the future, you need to be sure that you do this and don't do this. So they can send you a warning, although that's not an official disciplinary action. It's also really important to note that the Real Estate Commission only publishes 3 forms that are commonly used in our transactions, and it is the Working with Real Estate Agents brochure, the residential property disclosure, and the mineral oil and gas rights disclosure. They do not have anything to do with any other form that we use. The standard forms that we use, listing agreement, the offer to purchase and contract, our buyer agency, and even the rental agreements. They don't have anything to do with any of those forms. I was just talking to one of our brokers in charge in the Charlotte area the other day, and one of their agents had used a commercial form to, they were trying to list a home without putting it in the MLS, basically. And they called up the Real Estate Commission, and the Real Estate Commission told our agent to go ahead and use that commercial form to list this residential home. So, I'm going to tell you right now, the commission is not the place you want to call for advice on using forms unless it happens to be one of the 3 forms that they published. Any questions about the commission side of things? And y'all are able to mute and unmute yourselves. So feel free, if you want to type in a question, you can, but you are also more than welcome to unmute yourself and ask away. So if we've got nothing there, we'll move on to the Association of Realtors. Now, of course, when I say Association of Realtors, there's typically 3 levels that are involved. You've got the National Association of Realtors, you've got the North Carolina Association of Realtors, and then you've got your local association. In this area, I know we've got the Durham Association, Raleigh Regional Association, Johnston County Association. I think there's more. I think Orange County or Chapel Hill, I don't know what they call it, but I think they've got their own association too. So there's any number of local associations to which you may belong, but most of the policies and rules are set at the state and national level. So of course, important to keep in mind, so Orange Chatham Association, Craig's got us the official name there. The important thing to keep in mind with the Association of Realtors, their jurisdiction is only over other realtors. So, and keep in mind, you don't have to be a realtor to sell real estate. Fathom as a company requires that all our agents do become realtors. The Triangle MLS, they have a funny little loophole that effectively causes most people to become realtors because it's cheaper to join the Realtor Association than the non-member fee cost to not be a realtor. So effectively, most people in our area probably are realtors if they're members of the MLS, though it's not necessarily true. And if someone is not a member of the Realtor Association, none of these rules apply to them. So it's really important to understand if you feel like you have a dispute with another agent, you need to know whether or not they're a realtor. If they're a realtor, you have some options available to you to probably help you resolve those issues. So the main things that the realtor associations are going to enforce are going to be the code of ethics. I mean, that's really the one overarching set of policies that they apply across the country in every association, and that's one of the primary things that they are tasked with enforcing. And of course, it's a voluntary, mostly, organization. So the people who are members are agreeing when they join to abide by the code of ethics. And I will post this PDF in the event page when we're done, so you can have access to all of these. We're of course not going to read through or look at the entire code of ethics right now, but the link to the code of ethics is here in the PDF. And of course, now these are not the only policies and rules that the associations have, but these are the big ones. And of course, the clear cooperation policy is the newest one. And when you start talking about coming soon, the MLS clear cooperation policy plays a role in that, although it's not the sole deciding factor in exactly how coming soon listings are handled. Individual MLSs do have some ability. So for example, I believe the clear cooperation policy gives you, does it give you 2 days? And our MLS only gives you 1? I can't remember. I'm a little bit more strict than the clear cooperation policy. So the MLS does have some flexibility there, but of course, this is a relatively new policy. If you are listing homes, you need to make sure that you are familiar with this policy. And again, various disciplinary actions that are available to the Association of Realtors. They can warn you. They have an official means of warning you. They can reprimand you. The association does have the ability to fine you. They can actually, put a financial penalty on you if you take certain actions that are against the code of ethics, other rules and regulations. They can require you to take extra ethics training, and they can suspend or revoke your membership. And of course, a link to those sanctioning guidelines are here. And if you scroll, so most of this is designed to assist people who are on hearing judge what a fair punishment should be if they determine the violation has taken place. So a lot of this is going to be guidelines. If you ever have an ethics complaint against you, these are great information to have access to, because it's going to give you an understanding of what these panelists are looking at, what they're considering, and what guidance they are given if they do decide that someone has violated the code of ethics. But you can see some of these are not cheap fines. We're not talking about $50 or $100 fines here. This is a $500 fine, a fine of $2,000 or less, a fine of $10,000 or less. The association has the ability to inflict some pretty serious financial pain. Now, of course, those kind of punishments are not going to happen over some minor violation that was obviously unintentional. You're not likely to see those kind of penalties unless you really, you're a repeat offender, or if you've really done something egregious that just seriously violates either the code of ethics or some other rule or bylaw of the association. But yeah, you can see down here that they can really bump those up to some serious levels, up to $15,000 potentially. And of course, the ultimate punishment that they can administer is they can terminate your membership. Any questions or thoughts about the Realtor Association? Has anyone here actually been to an ethics hearing? I can tell you that I have actually been to 2 ethics hearings, once as the complainant and once as the respondent. And it's not a whole lot of fun on either side. And I just filed an ethics complaint against another agent fairly recently. So most likely at some point in the upcoming months, I will get to participate in my 3rd hearing. So yeah, it's not exactly an exciting process, but it is important that you understand how it works and exactly what kind of things they regulate. And on the topic of forms, the North Carolina Association of Realtors, in cooperation with the North Carolina Bar Association, drafts almost all the forms we use. So the Bar Association is mostly involved in drafting the contract forms. So at the bottom of Form 2T, for example, you'll see both the Real Estate Association and I think I need to close some of this stuff in the background. I'm getting a message that my audio might not be working so hot right now. Can everybody hear me okay? Okay, cool. So we will keep moving. Hardwired into some Google Fiber internet, so it better not be running slow. So the Association of Realtors and the Bar Association, you'll see both of them at the bottom of Form 2T, whereas if you look at Form 201, our buyer's agency agreement, you'll just see the Associated Realtors. But when we start talking about things like, hey, due diligence is super unfair to buyers right now, the Association of Realtors, specifically the state association, that's who you want to take those complaints to. If you want to see a return to a contingency style contract, the North Carolina Association of Realtors, that's the organization that made the decision to move us to a due diligence style contract about, 2012, 2011, nearly 10 years ago now. And that's the one and only organization that would be able to make the decision to provide us with contracts that no longer ask for due diligence fees. So on that particular topic, again, people say the real estate commission needs to do something about due diligence fees. They can't do that. They don't have the authority to regulate contracts between private parties. They can only regulate what we do. And so I should caution you that you got to be careful what you ask for with the commission, because if the commission came out and said that real estate brokers could no longer use contracts that require due diligence fees, and that change suddenly went into effect and sellers said, well, I still want due diligence fees, what that would do is actually encourage sellers to no longer hire brokers so that they could use these contracts provided by real estate attorneys that are perfectly legal to use, but that the real estate commission tells us we can't use. So that's a good a good reason that we don't want the real estate commission getting too involved in specific forms other than the ones that are mandated by state law, so that all sellers have to use them whether they work with a broker or not. Any questions about the association, in particular the forms? If you're not familiar, the legal hotline that we all have access to through the North Carolina Association of Realtors, if you call them up, those are the attorneys that are involved in drafting and updating these forms. Will Martin in particular, I know has been there a long time, and I think has been personally involved in drafting just about every form that we use. So those are the people that you want to talk to when it comes to updating contracts and forms. All right, so we'll move on to the MLS. And of course, being based here in the Triangle, we're going to talk about the Triangle MLS, although MLS rules can vary because not every MLS is closely affiliated with a realtor association. There are some MLSs in, I don't think in North Carolina, but I have heard of MLSs in other states that are actually owned by one of the local brokerages. And I'm not quite sure. That doesn't sound like a very fair setup to me, but I'm not sure, how those MLSs work. But, of course, the Triangle MLS, their jurisdiction is just subscribers to the MLS service. They can't make rules that applies to anyone outside the MLS subscribers. They are enforcing their own rules and regulations and their data integrity guidelines and their form of punishment. Similar to the association, they can warn you, they can fine you, and can suspend or revoke your membership. And again, when you start talking about fines from the MLS, they start out low with those little $100 fines for ticky things like, not updating the status in a timely manner. But they can get fairly hefty there too. I believe here towards the end, yeah, you fines of 500, 1,000, 2,000, 100, and 3,000 when you get up Category 4 offenses. And now again, these kind of offenses are not things like forgetting to update the status on time or, putting in the wrong, zip code for a listing. These are going to be things like giving out the lockbox combo to lockbox that is not locked. Giving access to people who shouldn't have access to other people's homes are serious violations, and they take those very seriously, and they punish accordingly. And of course, they do have the right to suspend your membership. But again, that's not something most of you will never, ever, ever even have to think about that, because when you get up to that level, you're talking pretty egregious violations, most likely done intentionally, and in all likelihood in a repeat manner, so that you've done something pretty bad over and over again. So, and then the MLS, when it comes to forms, they only have a handful of forms, and they are only for the purposes of following their own guidelines and rules. So, you know, the most commonly used ones are the Cummings form, being used a lot right now, and the withheld from MLS form. So on the topic of coming soon, this is where you would go if you want that to be changed. So there's a little give and take here between clear cooperation and the MLS rules. Our MLS allows a home to be coming soon for 30 days, automatically rolls over to active. I've seen some people argue that 30 days is ridiculous. There's no reason a home should ever be coming soon that long. And if you feel very strongly that this is the case, you're going to want to reach out to the MLS. The MLS has a board of directors. They are elected by us. Most of them are other real estate agents that we elect. So you do have a voice in how the MLS is run. And if you want changes in policies like coming soon and how long they can be in coming soon status, that's who you want to reach out to. Any questions from y'all on the MLS? So if we'll move on to the last one, and really just kind of lumped these together, the North Carolina legislature and the North Carolina courts. Of course, the legislature makes the laws and then the courts enforce them. And these are the only ones that have jurisdiction over your buyers and sellers. So, you know, of course, as it relates to real estate, the primary things that they're going to enforce that will impact us in any way are, you know, the statutes of fraud and universal commercial code. That is state law, super boring and really long. If you want to scroll through this, I think I used the search function earlier and found that the word contract was used in here something like 350 times. So not easy to find references specifically to real estate. But if you are really interested, you could read all the way through this entire, every article of this statute. And then contract law, which is not, this is a little more complex. There's not just one law that's being referred to. When you talk about enforcing contract law in the state of North Carolina, you're talking about years, centuries of case law. And, you know, this just linking to a book on North Carolina contract law. This book is $400. So as you can imagine, this is a very in-depth issue. And you know, it's not something that you're going to bother trying to learn. What you need to know is that and how this impacts us in real estate. These are the people that can actually enforce contracts. When a seller breaches a contract, there is no point complaining to the Real Estate Commission, complaining to the Association of Realtors, or, you know, it has nothing to do with the MLS, obviously. Now, you may believe that the listing agent did something wrong that maybe contributed to the seller breaching the contract, and that may be something that the Real Estate Commission would investigate. They may find something was done incorrectly. However, it's super important that you understand, no matter what the Real Estate Commission finds, all they can do is reprimand, suspend, or revoke that agent's license. They can do anything to force that seller to honor the contract. The only place any contract anywhere can get enforced is in a courtroom. So, you know, that's super important to understand. A lot of people think, you know, I want to go to the Real Estate Commission and complain and they're going to do something. Well, they may do something, but it's not ever going to be anything that helps your client get what they want. So just like in the notes here, you know, I've said that other than the clear cooperation policy, that's the one place outside of where a seller can essentially be to put your listing in our MLS, to opt out. And other than that one small exception, contract law, these are the only rules that apply to buyers and sellers. And that, just like the mineral oil and gas rights disclosure and the property disclosure, those are required by state law, not by real estate commission rules, not by any sort of rules that only apply to real estate brokers or realtors. So super important that you have an issue that you really want your client to get something out of it, the only option, whether that's suing the other party, the buyer or the seller, whether it's suing the real estate agent or the real estate firm. The only way that anyone can be compelled to basically give your client money or in some other way enforce the terms of the contract, remedies of the contract in the case of breach, is to go to court. So any questions or comments about any of this stuff?
Hey, Aaron, just one thing backing up to the very beginning when you're talking about the real estate commission. From what I've heard, I've been fortunate enough not to actually witness this, but if a complaint comes to them, you're right, they can't jump in and like accuse someone of a crime or throw them in jail or whatever, but if they think a crime has been committed, they will report it to wherever it needs to be reported to, and then that agency could, take action against the, I suppose, a client or an agent.
Yeah, they could always refer it, I guess most likely to the North Carolina Department of Justice or the State Attorney General's office. And yeah, that, so it's possible if they think something has really seriously, some law has been violated, they could refer it to the appropriate agency. Yeah, that they definitely could.
And presumably the NCAR or local board or whoever would do the same thing, I would think.
Yeah, they probably could. I guess I don't know if it would have quite as much weight coming from a private organization as it would another government agency. But yeah, I mean, in theory, anyone can refer. You can call the Attorney General's office and report, pretty much anything that you think is a crime. And I guess they will take a look. I know that we actually, kind of a crazy situation we had at one point. Some individual, I forget where they were, filed a complaint with the Attorney General's office claiming that we were harassing them and texting them and that they were asking us to stop and I forget all the details. Now, of course, we dug into it. We provided the Attorney General's office some records showing that someone had registered on an agent's website using that phone number. And of course, there actually were no records that they had asked us to stop. The first thing they did was file a complaint with the Attorney General. So I guess the Attorney General's office must investigate pretty much all complaints, because that one was relatively minor, and they still took the trouble to send us a letter and ask for an explanation. So you probably don't want to push your luck. Well, if there's no other comments or questions about this, we will go ahead and wrap this one up. Not a super long presentation today. It's relatively straightforward, but you would be surprised how often agents misunderstand who's responsible for enforcing the rules, and they'll complain to the wrong agency, or don't know where to take their complaint at all. So glad y'all could make it. Look for this recording. Of course, it takes GoToMeeting a little bit to transcribe it. Once it's transcribed, I'll upload it to my YouTube channel, and I'll post a link along with this PDF in the events for you to review at your convenience. All right, y'all have a great afternoon.